Yes, thank you, Judge. I'll just
do the introduction and then we start. Yes.
Thank you. This hearing is in the matter CFI-054-2018 before His Excellency Justice Ali Al-Madhani and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the Registry in Dubai on His Excellency's instructions. The applicant is represented by Dentons & Co. Lead counsel is Mr. James Whale. The respondents are represented by Ashish Mehta and Associates. Lead counsel is Mr. Peter Duckworth.
Well, Your Honour, as you're aware, Prime, the third defendant, has no involvement in this application and therefore isn't represented. Could I first check that you've received a skeleton argument from me, which is at Bundle O, tab 7, page 232.
I do.
And I'm grateful. And one from my learned friend, Mr. Duckworth, which is at O8, page 248.
Right, which is open before me now, yes.
I'm grateful. Your Honour, you'll have seen that Mr. Mehta and Renish have applied to adjourn these proceedings, and in due course I'll hand over to Mr. Duckworth to open his application. But it may assist that I set out at a fairly high level what the issues are, to introduce the issues, so that Your Honour is then in a position to see the adjournment application in context. Because in my submission it's important that the court is clear about what this hearing is concerned with, and more importantly, what it's not concerned with. Your Honour is not in this hearing concerned with the substantive dispute. That is the subject of your immediate judgment, which you handed down on the 27th of September. Now, as Your Honour has seen, Renish and Mr. Mehta seek to appeal your immediate judgment, but we're not hearing that application now. It's only if they succeed in their appeal and we get back before Your Honour in a trial that you will have anything to consider in relation to the substantive issues. Now, once that is understood, then in my respectful submission, quite a lot of the respondents' skeleton argument falls away, because quite a lot of their skeleton is seeking to address the court on the substantive issues and, put bluntly, why they say Your Honour got it wrong and why they're not liable for fraud, as Your Honour has found them to be. But that's not what this hearing is about. This hearing is solely concerned with the freezing order that Your Honour made in August and whether or not it's been breached. Now, the most helpful place to start in my submission is probably the application itself, which I don't know if you've got the hearing bundle to hand, but if you could please look at O5, page 226.
Sorry, what tab are we looking at now?
So we're looking in the hearing bundle.
O5?
Number O, tab 5.
Ground for committal.
Exactly. And this is the form that it was filed to the court in. I'll show you in a moment that the format. And you'll see that from paragraph 3 onwards, the relevant provisions of the freezing order are set out. And then the meat of it really begins at the top of page 3, or bottom of page 2, where the breaches are identified.
Right.
So, although there are a large number of breaches, they're very straightforward. So, the first breach is that Renish failed to provide information about its assets. The second breach is that Renish failed to set out what had happened to the money that had been paid into the NBK account. The third breach is that Renish failed to swear an affidavit, or someone on behalf of Renish did. And then the fourth breach is that Renish applied its assets for the payment of its legal fees. Now, breaches 5, 6, 7 and 8 are exactly the same breaches, but as against Mr. Mehta. And then breaches 9, 10, 11 and 12 are exactly the same breaches against Mr. Mehta, but by reason of the fact that he is the owner and controller of Renish. So if you were to find that Renish committed those breaches, in circumstances where Mr. Mehta is the owner and controller of Renish, we say that he is culpable for those breaches as well. Now, my lord, what happened, unfortunately, which is something that's out of our control, is that when the application gets filed at court, it gets reformatted. And if you look at, please, number O tab 4, you will see the application notice once it's been through the e-filing system.
Right.
And if you turn to O page 222,
Yes, I'm in.
about 3 lines below part C, it says the applicant seeks an order. Do you see that?
Not really. I can't find C, first of all, actually.
So this is on bundle.
I can see number 3, I can see number 4, 5.
I'm grateful. So all that's happened is it's exactly the same
Yeah.
material I've just shown you, but it's all been compressed into a single document. So the paragraph numbers still appear,
Yes.
but they appear in the course of a single piece of consolidated text.
Right.
So it will be easier for Your Honour to refer to tab 5, which concerns, which sets out the original formatting.
Right, but that is incomplete. I think it stopped with paragraph 22, and there is the rest of the document missing. Right?
No, the whole of this document at tab 5 is contained in the application notice. If you go back to tab 4, I can prove that quite straightforwardly, because you can see paragraph 22 at the end of tab 4. If you go to page 225,
Yes.
at the top of that page, there's a paragraph that says in the circumstances where
Yes.
where Mr. Mehta is owner. Just before that, it says you can see 22 dot. So
Yes.
that is the 22nd paragraph.
Oh, I see. Yeah.
So so Your Honour, that is the application that is before the court. So far as the substantive background is concerned, well, Your Honour is clearly very familiar with it. Your Honour has been involved from the very outset. Indeed, it was you who made the freezing order on the 2nd of August 2018, and then continued it. Just by way of high-level overview, it may be of assistance to Your Honour to remind yourself of the immediate judgment that you made, and that's at tab N.
Yes.
Page 37, but the judgment itself starts at page N39.
That's N9, isn't it?
N page 39, tab 5.
Yes.
And if you scroll down to paragraph 11, you'll see that it was SBN's case that it was induced to make the facility agreement because of fraudulent misrepresentations by Mr. Mehta and Mr. Ahmed.
Yeah.
At paragraph 12, you record the fact that a freezing order was applied for and that it was served by email and delivery to various addresses. Could I just invite you to briefly read paragraphs 14 to 21?
Yes, ma'am. Yes.
And then if you could please scroll down to paragraph 37, which is where you made your key findings.
You just said 37?
Paragraph 37, yes.
Right. Yes, right.
So you found that on the undisputed evidence that the inference of fraud was overwhelming, and then at 38, you made the point that it was common ground that Prime was never intended to supply oil to Lanka. Second, that the partial repayment was calculated to release further sums. And then in my submission, it's these further points that were the most powerful. Third, the cessation of all communication by Mr. Mehta in circumstances where they knew that SBM was owed money is fundamentally inconsistent with honest business conduct. Fourth, the abandonment of Renish's offices was further indicative of fraudulent conduct.
Right.
Fifth, at paragraph 52, the flight of Mr. Mehta from the UAE is a further indication of bad faith. 43, sixth point was the failure to respond to the freezing order. Seventh, the pattern of payments, which you'll have seen reference to above, included the withdrawal of round figure sums and payments back to Renish. There's the hallmarks of a sophisticated fraud. And then at paragraph 45, the court has no hesitation. Now, it's important to point out, Your Honour, that the findings that you made in that judgment were on the balance of probabilities, and it's also right to point out that that judgment is now the subject of an application for permission to appeal. But I hope, nevertheless, that it's of assistance to remind yourself of the background to this matter. Now, what we're concerned with, as I say, is the freezing order itself, and it's worth turning that up. It's at tab H, and tab H1 is the ex parte freezing order.
Yes.
And as you'll see, there is a clear penal notice at the top. Then what we're concerned with principally, well, I'll take it in stages. Paragraph 5 imposes a worldwide freezing order
Right.
on the assets of each respondent. Paragraph 6 defines those assets in broad terms, so whether they're jointly owned, legally or beneficially owned. And then what we're really concerned with for today's purposes is paragraph 9, and it's worth looking at that in detail. That's at page H4.
Amen.
And Your Honour, of course, the context to the provision we're about to look at is that without the disclosure of assets, freezing orders are effectively useless, because unless an applicant knows what the assets are, freezing unknown assets is of little use. You need to know what the assets are so that you can take proper steps to identify them and preserve them. So it's against that background that you made the order you did at paragraph 9. And what you ordered there is that within 2 days of service, so not business days or clear days, any days, including weekends, each respondent must, to the best of his ability, inform the applicant's solicitors of all its or his assets worldwide exceeding $10,000. And they have to give the value, the location, and details of those assets. Now, the second subparagraph required each of the respondents to tell the court, to the best of their ability, what had happened to the sums transferred into the NBK account. And once again, because of the urgency, you imposed a very tight deadline of 2 days. Now, moving on to paragraph 10, a more generous time limit was imposed, but still a tight one, 5 working days for the respondents to produce an affidavit. Now, Your Honour, there is no dispute between the parties today that until the 12th of December 2020, neither Renish nor Mr. Mehta took any steps whatsoever to comply with that freezing order we've looked at. The only attempt that has been made...
Well, how long is that? 2 years? Would that, is that 2 years,
Yeah,
I think?
It's over 2 years, Your Honour.
Over 2 years, yeah.
Now, it is the respondent's case before the courts today that they were only aware of the freezing order in October 2018, but that is still October 2020,
Okay.
but that is still 3 months before today, in circumstances where Your Honour set a deadline of 2 days. So it's worth us looking at what the respondents have in fact filed in belated compliance or purported compliance with the freezing order, and that's at tab P rather, at page P1.
The witness statement?
That's it. You'll find a very short witness statement of Mr. Mehta, and
Yes.
it's worth just looking at that briefly. At paragraph 1 on page P1, he confirms that he's the sole shareholder of Renish,
Yes.
and therefore, in my submission, is clearly responsible for Renish's conduct. But the important point is at paragraph 6. So this is the point I just made to Your Honour. He asserts, although we don't accept this, that he didn't receive any intimation about the worldwide freezing order. But what he says in the last sentence of paragraph 6 is important, because he says, upon learning about the WWFO, I sought legal assistance from AMA. Now, Your Honour knows that the grounds of appeal in this case were filed on the 18th of October 2020. So at the very, very latest, Mr. Mehta is aware of the freezing order by the 18th of October 2020.
Right.
3 months ago. So, in my submission, he ought to have complied with the freezing order on the 20th of October, but even now, he has failed to do so. Now, I want to return to the witness statement in a moment, but there's an important letter which Your Honour should be aware of. It's a letter from Denton's dated the 17th of November, and you can find that at tab O.
Yeah.
2, so tab O2, and it's at page 0198. We're looking here at the exhibit of Mr. Chung.
198, right? It's the letter of 17th of November 2020. Right?
Exactly. So,
Yes.
as you can see from paragraph 1.1, it was written 6 days after the grounds of appeal had been served on us. And we refer to that, but then importantly at paragraph 2, we refer to the worldwide freezing order made on the 2nd of August. And this letter enclosed a copy of that freezing order.
Right.
Now, at paragraph 2.2 over the page, Denton's make the point that AMA's clients remain in serious ongoing breach of the WWFO.
Yeah.
And then at paragraph 3, the relevant provisions of the freezing order are set out in the body of the letter. And then at paragraph 3.2, Denton's make the point that notwithstanding that AMA has been on the record for over 4 weeks, their clients have still failed to comply with the freezing order. And then we gave them an opportunity to do so at paragraph 3.3. and said at paragraph 3.4 that if we don't receive a substantive and positive response, we will bring committal proceedings in accordance with RDC 52. That, Your Honour, was on the 17th of November, 2 months ago. If we can go back then, please, to Mr. Mehta's witness statement at tab P1. And look, please, at paragraph 7, which is at P2. Now, he says he hasn't violated the WWFO. That's clearly a matter for Your Honour to consider.
I've seen this.
But what is really concerning to us is that in the second sentence, he says, I've operated my business in the UAE since 2006, and my movable, immovable assets, business accounts, and personal accounts were in the UAE. So he's clearly referring there to substantial assets, which ought to be frozen pursuant to the freezing order, but he's provided us with no details at all as to what those assets are. And we say that that is a clear breach of the freezing order. And our concerns are heightened by what's said in Mr. Duckworth's skeleton argument. I don't know if Your Honour has a hard copy to hand, or whether you're using the electronic version.
I'm using the electronic.
Okay, the electronic version is at 08, page 248.
Yes.
And if you could scroll down, please, to page 255 and look at paragraph 17.
Yes.
We're told, I think this is for the first time, but I'll be corrected if I'm wrong, that the respondents have relevant accounts with some 27 banks in the UAE, and yet no details whatsoever have been provided about any of those accounts. So, and it may be that there is some difficulty in obtaining underlying documents from those 27 banks, but there's absolutely no reason why Mr. Mehta or Renish should not have provided us with account numbers or names of the relevant banks. Now, at paragraph 19 of the same skeleton argument, a little further on, it is said that Mr. Mehta and Renish have no wish to violate the terms of the freezing order, and they will, if allowed sufficient time, do their best to provide all the information they can. Well, let's take a step back, Your Honour. Your Honour set a deadline of 2 days, and yet it's common ground that they had the freezing order on the 18th of October. Here we are on the 11th of January, and they're saying that they need more time, or they will comply if only they have more time. With respect, Your Honour, that is thoroughly disingenuous in all of the circumstances. So it's our position in summary, or it will be our position, that neither Renish nor Mr. Mehta has made any meaningful attempt to comply with the freezing order. They are in clear and deliberate breach of it. They must know what their assets are, and yet they haven't told the court what those assets are.
Well, Mr. Well, I see where you're taking me to. Would you please advise in the service of the committal application?
So the committal application was served on AMA because Mr. Mehta had taken flight and we had no address for him. Because you'll recall, Your Honour, he effectively absconded. He fled the jurisdiction once we were seeking to press him for payment. Yes. So it's been served on AMA, but there is no dispute that he's got it.
When?
In my submission, there are 2 dates where there can be no dispute. His own evidence is that he instructed solicitors or lawyers after seeing the freezing order
Oh, no, I don't talk about the freezing order. I'm asking you about the service of the committal application.
Yes, well, you can see that in the correspondence bundle, which is at tab Q, and it's at Q6.
Right.
So the application was issued on the 7th of November. There was a slight delay in getting it back from the court, and then once it was sealed, we served it on the 14th of December. Do you have that email?
This email is dated 5th of January.
No, Q6, tab 2.
Page Q21.
No, sorry, Q6, page Q6.
Oh, page Q6. Sorry.
It's not been suggested, I'll be corrected if I'm wrong, that this was not received when it was sent.
Are you saying this is deemed to be served in the same day? Is that right?
Yes. And you can see, I think it says 8:10 in the morning at the top of the email.
Yes, right.
I don't think any point is being taken on service, Your Honour. So dealing first of all with the service of the freezing order, it will be our submission that Mr. Mehta was served on the 2nd, but was deemed served, I think, on the 5th of August 2018. But at the very latest, he got it in October. And so far as the committal application is concerned, it was served on the 14th of December. So I'll hand over to Mr. Duckworth shortly, but I hope it's clear from that brief introduction that the issues which the court has to consider on this committal application are very, very simple indeed. It is simply whether or not Mr. Mehta and Renish have complied with the freezing order, and if not, have they got a good reason for that?
Thank you, Mr. Well.
Just before I hand over to Mr. Duckworth, I do make the point that it is in circumstances where neither Renish nor Mr. Mehta have any real defence to the committal application that they are now seeking to adjourn it, and I do invite the court to view this adjournment application realistically. A 2 to 3 month adjournment for an order that should have been complied with within 2 days of receipt. It is, in my submission, and this is no criticism of lawyers, cynical game playing on the part of the respondents. They know that they've got no defence, and they are simply looking to delay matters for as long as possible. But I'll let Mr. Duckworth open his...
May I ask you, Mr. Well, have you discussed a shortened adjournment between each of you instead of April?
We haven't, Your Honour. When I come to respond to Mr. Duckworth, it will be my submission that there is absolutely no basis for any adjournment. When you look at the authorities and the guidelines that have been developed under English law, the respondents have already had far, far more time than they would ordinarily be expected to have.
Well, my direct question to you, Mr. Will, is there is any, I would say, any acceptable, short time that, in your mind, in your assessment, that would be acceptable for you?
There's not, Your Honour, because they've already had double the time that they would ordinarily have had, and that would be if they were only aware of the committal application on the 14th of December. But as I've shown, Your Honour,
So how about 2 weeks from now, Mr. Wade?
No, Your Honour, that's not how freezing injunctions should be conducted. This is urgent.
We
are dealing with fraudsters. Your Honour has found them to be fraudsters. They have 27 relevant bank accounts, and they have failed to tell us what those bank accounts are. We are extremely concerned that assets are going to be dissipated. The only way in which the court can stop that from happening, and we can't guarantee it, but the most potent weapon that the court has to stop that from happening is to make a committal order. This matter ideally should have been dealt with 2 weeks ago. It's unfortunate that this is the first listing date, but there is absolutely no basis for an adjournment. that the defendants have been fully represented since October, and they've had ample notice that this matter has got to proceed today, Your Honour, in my submission.
Yes, Mr. Ware, thank you very much. I turn now to Mr. Duckworth. Am I pronouncing your name correctly?
Yes, you are. Thank you very much, Your Honour. Yes. I hope you can see me also. There was a time when I was blanked off, but am I visible?
I do, yes. Good. I see you clearly now, yes.
Thank you.
Yes.
My opponent, Mr. Wheel, for whose submissions I thank him, argues that you have no basis for an adjournment, not even for a 2-week adjournment, because this is highly urgent, and the defendants have been fully represented, he says, since October. You know, Your Honour, that that is not the case. They have only been fully represented since the 4th of January, when third-party funding became available. Whatever steps they took prior to then were taken in good faith in order to offer some assistance to a non-paying client. But of course, they can't be expected to act to the full extent that would be necessary to defend a case like this on a shoestring. Why is an adjournment sought by us? For 2 reasons. First of all, for reasons of justice, and secondly, for reasons of sound common sense. Dealing with justice, it's the unqualified right of any person charged with a crime or contempt of court to seek legal advice and representation. And how long that takes must depend on the circumstances. If I can just interpolate to say that, with respect to my learned friend, a lot of his submissions seem to confuse the issue of defending a contempt of court allegation and defending or furthering a freezing order. Of course, we accept that a freezing order requires a person to respond promptly, very quickly, but that's a very different matter from defending a committal allegation. In a simple case, for example, in the United Kingdom, we have people who can be sent to prison for committing acts of domestic violence, or in other jurisdictions you might have a situation where there's a breach of bail terms and a person needs to be arrested. A simple case may require only a short period for preparation. 14 days in those circumstances may be adequate. But a complex case like this may require significantly longer to prepare a defence, or even if there is no defence, to prepare a mitigation that may be equally important. There are circumstances in some of the reported cases to which Mr. Wheel refers where the interests of the claimant require an early hearing. I might bracket those as cases, for example, where a defendant is about to distribute illegal copies of copyright or patented material, where speed is of the essence. One needs to act very quickly to stop that. But this isn't that case. In this case, it said that we are in breach of an order made 2 years and 4 months ago. If that's urgent, then it's a different definition of urgency from the one that I know. And so I'm in difficulty complying with the order. It was suggested at one stage by Denton's on behalf of the claimant that the defendants were breaching the freezing order by instructing lawyers, because they must have put them in funds, and this can only have happened by withdrawing funds that were frozen. But that criticism is not now persisted in. Mr. Wheel accepts, on behalf of his clients, that the defendants had no funds, and therefore until a third-party funding arrangement came into being, their solicitors could do very little. As I say, that third-party arrangement is now in place, and happily we can now act in a fuller way. But the time since that has happened is very short. The 4th of January is only a week ago, and 1 week is scarcely long enough to prepare for a hearing like this. My second reason for asking for an adjournment on behalf of our clients is just common sense. To go ahead with a committal for which the defendants and their legal team are not prepared puts the defendants at a grave disadvantage. You already know that the claimant is seeking sanctions against the company, and in the case of Mr. Mehta personally, the loss of his liberty through being reported to the Attorney General. From a practical point of view, this is not likely to incentivize him to cooperate with the bank. More likely, he would stay away from the case. The bank will then lose out because valuable information it could have obtained from him will be denied to it, and thereby they risk increasing their losses. The information that may be provided and that is intended to provide on behalf of the defendants is a full affidavit setting out all that they know about bank accounts, receivables, any other assets in the UAE or elsewhere, and already we are in the process of nailing down that information because Mr. Wheel has already referred to that part of my skeleton argument that refers to the 27 banks.
What are you saying now? You're saying the committal order, if it succeeded, if it goes on and succeeded, it would then stop the defendant from complying with the freezing order. That would defeat, you think, the objective of the freezing order itself. Is that what you're saying?
I'm not exactly saying that. The freezing order has its effect because it's served on the banks and they can't release funds. It's the defendant's case. The bank accounts are already frozen through other means. But what the committal does is put the defendants in fear of cooperating in any way with the claimant.
Well, what kind of fear? Why you say fear?
Well, I suppose you might, to use a common analogy, one might call it carrot and stick. A stick may encourage them to comply, but reluctantly, but a carrot will encourage them to comply more readily. The carrot, so far as the defendants are concerned, is that they wish to reach an arrangement with all of their creditors. And so if they can assist in any way the bank, it will help them and help other banks. The claimant objects to our...
I'm afraid I have lost you for the last 10 seconds.
Oh,
right. Yes, right. Yeah. Would you please repeat what you've been saying for the last 10 seconds?
I beg your pardon. Let me repeat it. I said that there's a carrot and stick analogy here.
Well, yeah, I remember that, yes.
Yes, all right. And I said that we are already in process of drawing up a list of bank accounts. The problem that we have at the moment is that although the banks have been identified as institutions, the numbers of the accounts are not known to us, and we will have to ask those respective banks to tell us. This will require time. That sort of information is likely to be of advantage to the claimant for the very reason that Mr. Wheel has outlined to you. And therefore, allowing my clients time to compile that information is going to be in their interests. I turn now to the objections made by Mr. Wheel. He says, first of all, this is a clear case in which there really is no defence. We say, with respect, that's not the case. For a start, if the court finds that the defendant's access to the bank accounts has been barred, or that their assets are frozen by other banks, it may well find that any breach of the worldwide freezing order was technical, not intentional. There needs to be a deliberate act for you to find that committal is proved.
Well, I don't know if you with us, Mr. Duckworth, that even the result of the freezing order, the search order locally, resulted in almost nothing.
I'm not aware.
Maybe, I don't know, if you have read the report, I mean, in the paper, you might reach that conclusion.
So that's one of the documents, for example, in the case that we haven't had access to. So I don't know what they say. I'm sorry. In relation to the need for deliberate acts of contempt of court, I remind you that the draft order prepared by my learned friend recites this. If I could ask you to look at page 0219. This is the second page of a draft order prepared by my learned friends instructing solicitors. And you'll see in paragraph 3 it orders that the second defendant be referred to the Attorney General and or be sanctioned as follows: by reason of, little one, deliberate steps by him taken to assist and or permit breaches by the first defendant. So the claimant itself recognises the need for deliberate steps to flout the court's order. If it was beyond the defendant's power at the relevant time to comply with the order, then that is a valid defence to the committal. And furthermore, in relation to paragraph 9, subparagraph 2 of the worldwide freezing order, which requires the defendants to give an account, if they can, of what happened to the money in the NBK account, you will recall that it's the defendant's case that account was at all material times under the control of a third party, Prime Energy, who appeared in these proceedings at one stage. I appreciate in saying this that there are findings in the judgment that we shall need to displace in due course, that there was a circular movement of funds.
Well, I don't know if you have the evidence from Prime that the money will return to your client, Mr. Duckworth.
If that evidence exists, then I shall be in great difficulty on behalf of my clients. I recognise that. But we haven't seen the report that says there was a circular movement. I have seen your judgment, which says so, and you were satisfied on the evidence you had read. But we haven't seen the inquiry agent's report, nor have we seen the movement of funds in those accounts. So our position is therefore some in the dark. The second main reason that Mr. Wheel advances why there shouldn't be an adjournment is that he says to do so risks dissipating assets. Well, that may be so, but it doesn't really deal with the point that in the 2 years and 4 months since the freezing order was made, the bank appears to have taken very few steps to try and recover assets or to prevent dissipation. As we stand today, there is no evidence of dissipation, at any rate of which we on our side are aware.
Well, I think that's unfair criticism. I think maybe to the claimant. I'm not defending the claimant actually, but when you said he did almost nothing to recover this money, but it's really, I mean, it's very difficult without the defendant, complying with the freezing order and identify their assets. It will be very difficult, for anyone to track an assets. This is maybe in the last 2 years, this is maybe 10th or the number 11th case that we're a bank trying to recover money from facilities like this without any result, because they could not identify any asset. They could not track the assets itself without the help of the defendant himself.
No, well, that, if anything, if I may respectfully say so, supports the point I'm making, that it's to the bank's advantage that the defendant gives disclosure of what it knows. And
well,
the
you
fact
have to give the disclosure. It doesn't matter whether we provide the committal order or not, I think, Mr. Duckworth.
Well, that's true.
The compliance with the order must go on either way.
Well, indeed, and that is actively being looked at. But before punishing the defendant for non-compliance, it's worth seeing whether he has made a genuine attempt to comply. And that is his intention, as we are instructed. You will recall that he took no part in the original proceedings, so he was not engaged with this case. But now he is engaging with the case, which is a very important step forward. And it's one that I invite the court to support and encourage. If there really is a fear that notification of committal application and not dealing with it quickly allows the defendants a further opportunity to dissipate funds, what I might comment, why when booking this application on the 14th of December did the claimant accept a date in this court that was 4 weeks away? Those 4 weeks give ample opportunity to dissipate assets if that is the fear. I respectfully suggest that that isn't a real fear in this case for the reasons that have already been outlined. A third reason why our application is objected to is that the defendants need to be taught a lesson, and giving them further time simply allows them to get away with murder, as it were. But that is not so. the defendants are trying to comply and are trying to assemble information that will be helpful. Now, may I just turn very, very briefly to the rules of the court in section R, tab 1, part 52 of the rules of this court. And I turn to paragraph 20, if I may, sub-rule 20.
Yes. Yes, I'm with you.
This sets out a route map for dealing with committal applications in this court.
Right.
The first point in 5220 is that in dealing with any committal application, the court will have regard to the need for the respondent to have details of the alleged acts of contempt and the opportunity to respond to the committal application.
Right.
This doesn't mean opportunity to respond to the freezing order. It means opportunity to respond to the committal application. If, for example, the defendants have a defence that it was unintentional, then they can go on affidavit to say so, and they will be cross-examined on that, and you will form a view whether that's a genuine objection or not. But that's the sort of opportunity this rule implies. 5221. The court should also have regard to the need for the respondent to be, 1, allowed a reasonable time for responding to the committal application, including, if necessary, preparing a defence. That's nothing to do with 2 days or 14 days. That's a reasonable time. That's a very broad expression. It's a matter for discretion for the court. 2, given the opportunity, if unrepresented, to obtain legal advice. Well, Mr. Wheel waves his fist in the air and says, they went to solicitors in October. But that's all very well. The solicitors acted without any fee to put in a notice of appeal. They weren't able to give full legal advice because they simply hadn't got any funds with which to do so. That position was only rectified as of 7 days ago. And 3, if unable to understand English, allowed to make arrangements, seeking the assistance of the court, if necessary, for an interpreter to attend the hearing. It's all very well for us to go ahead this morning with a committal application, but Mr. Hitesh Mehta, who appears on this call, is not very familiar with English. He can handle English, but things have to be explained to him 2 or 3 times. He may need an interpreter. That's something we are looking into. So that's the position on the rules. Can I turn next to the quotation from Arledge's work on contempt, referred to by my learned friend, at page R135.
R135.
Yes.
Is that the page number or the bundle reference? What is it?
That's the page number. It's section 12.
Yeah.
Arledge, Eady and Smith on contempt. Can I just read this first paragraph?
Yes.
What is clear, however, is that the bona fides of contemners and their reasons, motives and states of mind have long been recognised as relevant factors in mitigation. It seems, for example, that no casual or accidental or unintentional disobedience of an order would justify either commitment or sequestration. Where the court is satisfied that the conduct was not intentional or reckless, but merely casual and accidental, and committed under circumstances which negative any suggestion of contumacy, while it might visit the offending party with costs and might order an inquiry as to damages, it would not take the extreme course of issuing an order either of commitment or sequestration. It's a very important factor in this case to know whether Mr. Mehta's or the company's acts were intentionally disobedient. It's not only is it a defence, but even if the case goes against them, it's mitigation. They should be allowed to put forward that matter in their defence. They haven't done so within the time available for the reasons that I've discussed. May I next turn to page R148. This is the White Book,
Mm-hmm.
the rules of the Supreme Court. And there's quite a helpful passage on hearing date, adjournment or stay. The rules in England are really identical for all practical purposes. And
Yes, I'm with you, Mr. Duckworth. Yeah.
thank you very much. If I can pick up the second paragraph here under this heading hearing date.
The normal case management, yeah.
Yes, the normal case management powers as to the staying of proceedings and adjourning hearings apply, subject to the consideration that because of their nature, committal proceedings should be issued promptly and dealt with without delay. Where committal proceedings are brought, etc., they should be promptly determined. It's important to demonstrate that orders cannot be flouted with impunity. Where an unrepresented respondent's application for adjournment to enable representation to be obtained has been granted, the court may refuse to grant further adjournments for the same purpose, where to do so might not be in the interests of justice and may unduly prejudice the applicant for committal order. Well, I think that perhaps adds nothing to the submissions that I've already made, but there is a note in the second paragraph of a reference to a case called Lomas and Powell in 2003. And I thought it might just assist the court if I took a little detour here to look at that authority to see what the court actually was dealing with and how it dealt with it.
Why not? What that?
Thank you. It's number tab 15 in this authorities section.
Yes.
And if you will kindly look at that, you will see that it was an appeal from Liverpool County Court in a domestic matter. That's not immediately apparent, but there were issues over administering an estate. A paragraph that I would like you to look at is at page R237. Paragraph 49.
Mm-hmm. Yes.
This was a case about domestic violence, and in the UK, domestic violence has a number of criminal and civil remedies. It may be a contempt of court, there's a civil remedy for damages, and there's criminal penalties for committing acts. And so the question sometimes arises, in what order should these be taken? And paragraph 49, which is offered as one of the authorities to the White Book commentary in about dealing with promptness, is perhaps relevant. Experience suggests that proceedings in the criminal justice system are likely to require more extensive preparation and to prove more protracted than committal proceedings in the family jurisdiction. Therefore, the application to commit should be issued promptly after the alleged breach and listed without delay. That discipline will ensure that, if proved, the contempt will have been punished before any sentence in parallel criminal proceedings. So why I refer to this case is there's a special reason in domestic violence proceedings why committal should be dealt with promptly, and it's set out here. But those reasons have nothing to do with the kind of case we're dealing with, which raises separate considerations. I appreciate that I'm taking a little bit of time to go through these, but if you will bear with me, I should be grateful. Could I look at R149?
Yes.
Thank you. This is the White Book again, paragraph 81, 28, 3, and it's how the court gives case management directions at a hearing like this. On the hearing date, the court may proceed to hear the committal application or give case management directions, and for the purpose of ensuring the respondent is treated fairly, should have regard to particular matters, so that the rule, in other words, is identical to the rule of the Dubai court. Those matters include the need for the respondent to be given an opportunity for underrepresentation to obtain legal advice, and so on, and so on. An authority is referred to there, James and James, which is another family case. And I'm going to, once again, to invite your indulgence while I briefly refer to that authority, which is at number 14 of this tab, tab R14.
No worry, Mr. Duckworth, yes. Go on.
Thank you very much. This again is a family case, though I think it concerned inheritance rights rather than a dispute between husband and wife. Two members of the same family were appellant and respondent to the appeal. It's only one very short passage I wish to refer you to at page 229, R229.
Yes, Amen.
About halfway down the page, there's a paragraph that begins, I do not consider. Do you see that, Your Honour?
I do see it, yes.
Thank you very much. I do not consider that this appellant should have been the subject of an order for committal, ... until she had had a proper opportunity to have a solicitor or barrister make representations on her behalf to the court, or alternatively until she had expressly been given that opportunity with one adjournment, and then deliberately failed to take reasonable steps to obtain legal representation. That is precisely what we are seeking this morning, an adjournment to enable the defendants to be properly represented. Lastly, and this is my last legal point, in my opponent's submissions at page 0235,
Oh, 235, yes.
or perhaps I can just take it from the foot of the previous page, 234.
Mm-hmm.
Here, Mr. Wheel is dealing with the need to deal with committal applications promptly, and he then cites a passage from the White Book, which he sets out at the top of page 235. We have already looked at this, and we've looked at the case of Lomas and Powell, which is referred to. But in the second paragraph of the quotation, we're given some insight as to what is meant by dealing with the matter promptly. It says, where allegations are made that a freezing order has been breached, the claimant may bring a contempt application as a means of putting pressure on the defendant to comply. And then it cites the Dudurian case, Dudurian Group and Sims.
Mm-hmm.
For that, it will usually be appropriate to determine the contempt application promptly and before the trial of the underlying action, though the interests of fairness might sometimes require that it be determined after the trial. So promptness in this context is not about dealing with it in the next fortnight, but about dealing with it before or after trial. That's a very different proposition. Here we may have a trial because belatedly the defendants have come to the proceedings, and although they've started an appeal, the consideration is now being given actively to an application to set aside your immediate judgment and to have a proper defence. So that will be the trial in the action, and we will know for sure then whether they were acting in a fraudulent way towards the bank. Those allegations are of course denied. So I think I've now made our case in relation to the need to adjourn. I'm not going to take you through the fraud findings because, as Mr. Wheel rightly says, they are peripheral in the sense of this morning's decision. But I just want you to know, Your Honour, that the defendants believe they have a very valid defence to the allegations of fraud, and that all of the documentation in this case relating to shipments of oil is on back-to-back contracts. There was no counterfeit documents, there was no forged documents, and we already have exhibited some papers from Lanka Oil and from Prime that support this. There's more to come.
Well, I see your submission, Mr. Duckworth. My question, I mean, what I clearly see Mr. Wheel, I would say, contest to the application completely, and maybe to the time that you're asking for beyond April hearing.
Yes.
But I join Mr. Wheel, that won't be realistic. But what is the shortest time in your assessment that where you could submit a defense to this committal application? If the court is minded to grant to go on with this, what kind of, I mean, proportionate time you think be good?
I respectfully submit that a minimum of 6 weeks is needed for the defendants to get all of their facts straight and for their defence to be prepared. The only thought of putting the trial back to the 1st of April was to give the claimant an opportunity to respond to that, as in fairness they perhaps ought to have. But we on our side will do all that we can within 6 weeks to not only to provide information but also to put up the defence, whatever defence we have, to the committal application. The reason I'm not saying a fortnight is that third parties have to be written to here to find out the facts, and whether they will assist us, whether they will have to be written to repeatedly, or in some other pressure brought to bear on them, we don't know as yet. It would be a pity if the exercise stopped short at the point where we hadn't yet got the answers that we need from third parties and that the bank needs from our third parties.
Why do we need to refer to third parties here? I mean, the committal application is about the defendant intention not to comply with the order by themselves. And one of the difference that we didn't know about the order, we haven't heard about the order, we know where the money is, we know what the information is, we know what kind of available information is. Maybe the bank account is frozen, but we might be, because as a customer of the bank would serve us with a statement of account all the time. That we do have a periodic statement of banks all the time. Me and you, Mr. Weed, all of us. Maybe it's good to write to third party in order to, let's say, comply with the freezing order, but not to defend the committal application. The committal application, I think it's completely something else, Mr. Weed. I appreciate if you try not to mix up between the two things, between the submission and the defense of the committal itself. It's all about your intentions, Nick.
No, I see what you're saying, and I think that I perhaps am confusing the two just a little, or letting them run into each other. In being invited to find that we have been in deliberate breach of order, it will be necessary for us to show that we have made all reasonable attempts to contact third parties for the information that we need. Of course, if they don't respond in the time, then at least we've made the attempt, and that may provide a defence. I was thinking one step further to assist the bank by actually providing real information about where assets are situated, which is what we would like to do in our own interests as well as the bank's. But if the court feels that is being too generous to the defendants, then I won't stand out strongly against a shorter adjournment. But I think I've put my case on that fully.
Well, that's how I usually think, Mr. Duckworth. I mean, I'm not. It would be very difficult for any judge or any even investigator to take a decision before hearing a defense from the person that could be charged with a very maybe vital order. It's it's not a practice in this court that we deny a defense, but request for a proportionate time must be made. I mean, week would work for me. Even I do think even 6 weeks is when I asked Mr. Wheel about 2 weeks for your clients to submit a defense, I literally thought that is a proportionate time from my side, and then we would give Mr. Wheel another proportionate time that he think fit for him to reply to your defense, and then we allow the hearing. So I thought 2 weeks for you, 1 week for him, and then we have hearing in 3 weeks' time, unless he wishes to have more time. That was what was in my mind, and yes, then I'm sure that there will be also a cost issue in regard to the adjournment. Could be wasted cost, could be reasonable adjournment, could be cost in a case. But I will think about that, and I will ask Mr. Wheel to address me in these two things anyway.
Yes.
Yeah, Mr. Wheel.
Yes, Your Honour. I appreciate Your Honour's just given an indication that your current thinking is along the lines of a short adjournment, but I would be grateful if I could have an opportunity to explain why even a short adjournment.
Yeah, that's why I refer to you now.
I'm grateful. Can I just deal with 3 points that my learned friend made early on? First of all, he says it's not in our interests to expedite the committal proceedings because implicitly it was suggested that Mr. Mehta is going to take flight yet again. Well, my lord, that is an astonishingly unattractive submission. And not only that, but it is indicative of the sort of person we're dealing with here. And that makes it all the more reason why this matter needs to be brought on urgently, because we are dealing with a dishonest litigant who, through his counsel, has more or less said, if you press a committal order against me, I'm not going to cooperate. Now, in dealing with someone who is that dangerous, they need to be apprehended in short order. The second point is that my learned friend says it's not urgent because this matter's been rumbling on for two years. And that is a bad point as well. We are being told for the first time that there are 27 bank accounts, none of which has been provided to us. We need to know this immediately because we need to follow the fund flows from these bank accounts. We need disclosure from these banks. Your Lordship knows as much as anyone else how easy it is in the modern age to transfer funds electronically. If this hearing is put back by 2 to 3 weeks, who knows what's going to happen to those assets? And it's possible that it may be too late to the extent that some transfers may have already been made, but at least we can start the process of tracing these funds and preserving those assets. So there's no question as to the urgency of this matter. The third point that my learned friend made, well, they need more time in order to make inquiries of third parties. But Your Honour was absolutely right. Third parties are irrelevant. The order required the defendants themselves to tell us their assets to the best of their knowledge and ability. They do not need a single document from a third party to do that. Now, so far as the committal application is concerned, it is extremely simple and narrow in scope. All we say is that the 4-page witness statement provided by Mr. Mehta was too late and it didn't comply with the freezing order. That is a very, very simple matter for the defendants to respond to. So there is no reason why they couldn't have done so already. No reason at all. Now, if I could just have a quick look at some of the legal authorities that Your Honour was shown, because one needs to look at them in a little bit more detail in order to understand why in this case there really is no cause for an adjournment. It's worth starting with the White Book, which is the authoritative guidance in England, and look at page 148.
Is that R148, isn't it?
R148, yes. Now, my learned friend rather skated over the first paragraph of this section, headed Hearing Date, Adjournment or Stay, because the last 5 lines of it are important. The purpose of the 14-day rule is to ensure that the alleged contemnor has sufficient time to instruct solicitors to obtain evidence and properly advance his case. So the rules work on the premise that the starting point, at least, is that 14 days is a sufficient time to ensure that an unrepresented litigant has the time he needs to get lawyers on board and properly advance his case. Now, of course, in this case, we are not dealing with an unrepresented litigant. You are dealing with a litigant who has been represented by AMA since October. So this litigant, or these litigants, already have a very considerable advantage compared to the unrepresented litigants which the rules are referring to here. Now, in relation to freezing orders, my learned friend did take you to this passage. This is the 4th paragraph down that says where allegations are made that a freezing order has been breached. Now, the primary position is that the purpose of a committal application is to put pressure on a defendant to comply. Now, if you were to make a committal order today, you would put very significant pressure under Mr. Mehta to comply, because he would be anxious to purge his contempt. And the only way he could purge his contempt is by complying with your order and saying, I should no longer be referred to the Attorney General of Dubai, because here is my affidavit that now sets out my assets. If, as my learned friend invites you to do, you simply adjourn this matter off, whether it be for 2 weeks, 6 weeks, or 3 months, all you will do is alleviate the pressure on the defendants to comply with the order, because they will have very substantial breathing space and an opportunity to further dissipate their assets. Now, my learned friend accepted that we are not here dealing with a case where there is to be a trial in due course, because the trial has happened and your lordship has already given judgment. It is only if they succeed in appealing your lordship's judgment that there will be a trial, but that is entirely speculative. Now, I want to look at the James and James Authority, which is at tab 14 of section R of the bundle, because there are some important details in this case that, again, my learned friend skated over.
Well, Mr. Weir, let me be honest with you. What's it's troubling me now between myself and moving on with your application is that what Mr. Duckworth have confirmed to us that the real representation, the payment of the legal fees just happened in the 5th of January. Or maybe after the 5th of January, and that, we're not expecting a law firm to really work, to prepare, to advise, to submit before they receive some money. And then he confirmed that the third party's funding just happened very recently, and that is not a really sufficient time. And the court, would always be, even personally, I'll be very slow to make order, committal order maybe before, giving chance to defend.
Your Honour, I wanted to address that point head on, and
yes.
let me deal with it now. Could you turn to section N and look at tab 7?
Yes. Grounds for appeal?
Grounds of appeal. This document was served on the 11th of November, but I think it had been prepared since October, because the notice of appeal was dated the 18th of October.
Mm-hmm.
Now, what you see here is a very, very detailed, it's a 33-page document. If you could scroll down until you get to paragraph 29.3. And just while you're doing that, Your Honour, you should note that some 70 exhibits were filed with the grounds of appeal.
Mm-hmm.
And then when you get to 29.3, you'll see that detailed submissions are made in relation to authorities.
Right.
And likewise 29.1. So, Your Honour, you need to be very, very careful about the submissions that you've heard from Mr. Duckworth. What has been said is that AMA were prepared to act without being paid up until now. And as I've just shown you, not only were they prepared to act, they were prepared to make very, very extensive efforts to submit long and complicated legal documents in relation to the substantive appeal. Now, it is a telling factor against the respondents that they have chosen to channel their legal resources and the focus of their work on appealing Your Honour's substantive judgment, when efforts could very easily have been made through AMA to prepare a response, first of all, to the freezing order, and then to the committal application. So it's not a case of the solicitor saying, I'm happy to act for you in principle, but I'm not going to do any work until a funding arrangement is in place, because very substantial work has already been done. And AMA could not professionally submit to Your Honour that they would have been happy to do work in relation to the substantive case, but not in relation to the committal application. Either they're professionally engaged on this case and are prepared to work without being paid up front, or they're not. And as I've shown Your Lordship, they are. So, in my submission,
when this document was prepared, November?
It was prepared over the course of October and November.
Oh, yes.
It was served on us on the 11th of November. So, in my submission, although it's an attractive point to say that more time is needed to engage legal representation, in the circumstances of this case, it is a very bad point, because you've got lawyers acting in earnest several months ago. Now, with that in mind, could I go back to the legal authority?
Yes.
The James and James case, which is at tab 14 of section R. And there are some quite important factual features which haven't yet come out. But if you go to R219,
yes.
The 7th paragraph on that page, 1, 2, 3, 4. So, just to put this in context, Your Honour,
Yes.
this was a hearing which took place on Wednesday, and what the judge said, and this was a litigant who had no solicitors or barrister, and what the judge said in that case was you can have until 10 AM on Friday morning, at a time when the respondent was in prison. Now, it was in those circumstances, if you look at R227,
Yes.
on the final paragraph of that, it says, turning to the hearing on the 11th, the judge was clearly right to advise the appellant to obtain legal representation, but it is unrealistic to have supposed that she could have done so from prison in 1.5 days. That is miles away from this case, Your Honour, because we're not dealing with an unrepresented litigant at all. They've had AMA, DIFC practitioners acting for them since October. And then if you scroll down to 229, this is another important point. The second paragraph beginning, I do not consider. Do you see that?
What's the page number? What's the reference number again?
R229.
Yes.
And there's a second paragraph that begins, I do not consider.
Yeah, been taken to this by
But the important point is it says, if she failed to attend court until she had a proper opportunity to have a solicitor or barrister make representations on her behalf.
Mm-hmm.
So what the court is concerned to ensure is not that the person can put together their preferred legal team over a long period of time, but they've got someone competent to advise them and act for them. Now, on the evidence before this court, Mr. Mehta sought and obtained AMA's advice in mid-October. Now, it's important to bear in mind, Your Honour, that committal applications can vary hugely in complexity. Sometimes committal applications can take several weeks, and there can be difficult questions as to what exactly the order means, what exactly the acts or omissions perpetrated by the defendants were, and whether or not the defendants were culpable for acts of third parties. My Lord, none of those complexities arises in this case. The disclosure provisions in the freezing order are standard form and extremely straightforward. Mr. Duckworth has not submitted and cannot submit that there was any difficulty in understanding what they mean. It is undisputed in this case that apart from Mr. Mehta's witness statement dated the 12th of December, not a single step has been taken by either of the respondents to comply with the freezing order. So as a result, the only question that arises is whether or not the respondent should have acted before the 12th of December. In my submission, the answer to that question is so obvious that one only needs to ask the question to know what the answer is. And then the second point is whether their witness statement at a very late stage complies with the freezing order. Again, that's a very, very simple question that simply turns on what the witness statement does and does not do. So, whilst I fully endorse what Your Honour has said and indicated about the importance of defendants having a reasonable opportunity to defend themselves, the key is in the word reasonable. And on the facts of this case, the court can have absolutely no doubt that Mr. Mehta has had a full opportunity, much fuller than many other litigants in the context of committal applications, but he has simply chosen not to submit a defence when he could easily have done so. I've already said that the suggestion that they require access to third-party documents is a complete red herring. They don't need any access to third-party documents. They simply need to explain their own conduct, and that is within their own knowledge. And I emphasise again Denton's letter of the 17th of November, because that, in my submission, really puts the position beyond doubt. If the very first time that it was suggested that a contempt had been committed was on the 14th of December, the defendants might have had some argument that even 4 weeks wasn't quite sufficient. But they had a month's notice before then, at a time when AMA were fully engaged and acting for them. So they've really had 2 months, Your Honour, to get their house in order. And you shouldn't take seriously a submission that says that that is not enough, or that is not a reasonable opportunity in all the circumstances of this case. Now, so far as Mr. Mehta's cross-examination is concerned, it was confirmed to me yesterday by Mr. Duckworth that there was no intention for Mr. Mehta to give any oral evidence. So in a sense, the translator is a red herring, but it's also a red herring because his witness statement is drafted in fluent English, and there is no indication in that witness statement that he has any difficulties understanding English. So in my submission, if he had any honest evidence to give, he would be giving it to Your Honour. The fact that a tactical decision has been taken for him not to give oral evidence, in my submission, is a telling factor, and it's not one that should deter the court from getting on and hearing the committal application today. Now, Your Honour needs to consider very carefully what exactly it is that the respondents haven't had an opportunity to do, which a further 2 weeks or 2 months, or however long it may be, will give them an opportunity to do. Now, the first question is, have they had an opportunity to obtain legal representation? The answer to that question is yes, because AMA have been acting and they have prepared detailed legal submissions in the form of the grounds of appeal over 2 months ago. So an adjournment won't make any difference to that. Will an adjournment allow them an opportunity to prepare a defence when they haven't already had an opportunity to do so? Your Honour, they've had 2 months. If they haven't prepared a defence in those 2 months, the obvious inference, and in my submission the only inference, is because they don't actually have a defence to give. The third question is, have they managed to arrange someone to represent them at this hearing? Well, AMA could have represented Mr. Mehta at this hearing. they've chosen to instruct London Council, and I forget the date. Mr. Duckworth will perhaps remind me, but Mr. Duckworth has been instructed for a number of days and has had the benefit, of course, of all of the knowledge, the pre-existing knowledge of AMA. I think Mr. Duckworth confirmed to me that he was briefed on this case on the 6th of January, so 5 days ago. And, Your Honour, this is a hearing that has a time estimate of 2.5 hours. Given the relatively narrow issues in dispute, 6 days or 5 days is more than sufficient. So, for all those reasons, in my submission, there should be no adjournment at all, even though the court may naturally be thinking that there's, normally, in ordinary circumstances, some merit in a short adjournment. Those circumstances just don't exist in this case. We are ready to proceed today. The matter is urgent. The respondents have had ample opportunity. In my submission, the court should just proceed.
Thank you very much, Mr. Will. Mr. Duckworth, do you want to have a last go?
Thank you. I have very little to add, really. I think this has been a long enough hearing already. But a lot of Mr. Wheel's submissions are premised on the basis that the defendants have had active legal representation since October. You know that this is not the case. The fact that their lawyers took some pro bono steps to hold the ring until they could be properly instructed
But this
is
is
now
a new point, isn't it?
whose point is new one?
The pro bono. The pro bono point.
No, it's mentioned in my skeleton argument.
Yeah.
They acted without fee is what I'm saying. I don't want to get technical.
Yes.
But of course they couldn't be expected to go on doing so, and they haven't been able to prepare a proper defence. I've only come into the case 6 days ago, as Mr. Wheel says. I don't have their full instructions, and it's unsatisfactory. If this were a criminal trial, the defence would be given a lengthy period to prepare their defence. It's not much different from a criminal trial. The penalties are similar, and so by analogy, we should have a reasonable time to prepare. I don't think I can add anything more than that.
Your Honour, if I could just confirm, I don't think there is a reference to pro bono in my learned friend skeleton argument, but there it is.
Yeah, I didn't recall so. Sure. Well, I would adjourn for now. I mean, so Mr. Will, if I decided that the defendant is not to be granted any further time, what is the next step? Does that mean we should go and grant your application? So because it's uncontested and undefended and.
It's not undefended in the sense that lawyers are here. In view of the submissions I've made, I would anticipate it would take about 20 or 30 minutes to deal with the application because it's so simple. And I do invite you to proceed. I will make my submissions in a very fair and balanced way, and both parties will have full opportunity to draw to your attention all relevant matters. But this is a case where realistically there is no defence and there is no benefit in the matter just lingering on, particularly when assets could be dissipated. So if you were minded to refuse the adjournment, yes, I would open the application and it would be dealt with, I anticipate, in about 30 minutes.
And would it be open to Mr. Duckworth to make any defence then?
Absolutely, it would be fully open to him to make a defence, and indeed it would be his right. Yes.
Yeah, I see that. Then I would take off 30 minutes break. Then we will be back.
I'm grateful.
I'll see you then. Thank you very much. Yeah.
Yes, Judge.
Do we have all parties assembled?
Mr. Duckworth, can you hear me?
Can you hear me?
Yes, yes, we can hear you.
Can you see me?
We can't see you.
All right, now hopefully you can now.
Mr. James Whale, please, could you confirm that you can hear us as well?
I can hear you clearly, yes, and I can see Mr. Duckworth now.
Yep.
Well, good afternoon, gentlemen.
Good afternoon.
Well, in that short break, Mr. Duckworth, unfortunately, I have decided to go not to grant the adjournment application and to reject it based on unreasonable conduct from your side. And I will hear Mr. Wheel now submission on the application for a committal order. And then I will give you the opportunity to defend yourself afterward, or I might even give you the chance of a very short written submission and maximum no more than 2 days, if you wish to do so.
Thank you.
I'm grateful, Your Honour. Your Honour, I said I would be objective and balanced in my submissions, and with that in mind, I want to start by highlighting to the court procedural safeguards that a defendant is entitled to in a committal application. And I draw attention, if I may, to paragraph 20 of my skeleton argument. And my skeleton is at tab 7 of O.
Yes.
Now, this hasn't actually found its way into the DIFC rules or the notes to the rules, but given that it is well established in English law, I'm proceeding out of an abundance of caution that these procedural safeguards also apply in the DIFC. And I'd like to go through each one, if I may, and briefly set out the position in relation to each paragraph. So do you have paragraph 20?
Yes, I have it open before me.
So this is from a Court of Appeal decision in Re L. A Child and Mr. Oddin. And just dealing with what's said there, this is a judgment of Mrs. Justice Tice, and she says that before any court embarks on a committal hearing, it should ensure that the following matters are at the forefront of its mind. Now, the first matter is there needs to be clarity as to what the foundation for the contempt is. Are we concerned with contempt of court in the face of the court or breach of an order? Well, the answer to that question is we're concerned with a breach of an order, and in particular a freezing order. The second point is that the contempt should be set out clearly in a document or application. Well, I've taken Your Honour to the grounds, and in my submission that is clearly satisfied. We've identified clearly and numerically each of the alleged breaches. The third safeguard is that the person has been served with the order and it contained a penal notice. Well, you've seen the penal notice in the freezing order, and you've got evidence that it's been served. Since October. Fifth question, should you hear the committal application or should another judge hear it? Well, in my submission, it's difficult to think of any person on the planet better placed than Your Honour to deal with it. It's your freezing order, and you've got more knowledge of this matter than any other judge in the DIFC.
You mean familiarity with the case?
Well, you've dealt with a number of applications, Your Honour. You've given the immediate judgments, so you are preeminently placed to deal with this application. The sixth point is whether or not the person accused has been advised of their right to remain silent. Well, if they haven't already noted it from my skeleton argument, they note now that Mr. Mehta and Renish are not under an obligation to give evidence unless they choose to do so. They have a right to remain silent. And then the seventh point is that if they do choose to give evidence, they should be warned about the privilege against self-incrimination. Well, given that neither a representative of Renish nor Mr. Mehta is giving evidence, that doesn't arise. So those, Your Honour, are the procedural... Oh, sorry, there are two more. They continue over the page. So it's important that Your Honour is aware that the finding that you make on committal must be to the criminal standard. You have to be sure that Mr. Mehta and Renish have breached the order, not merely that it's more likely than not that they did so. And then the final point, and this only arises in your judgment in due course, is you need to set out in your judgment what the basis for the finding of committal is. But that's for the next stage. So those are the procedural safeguards. In light of the submissions that I've made so far, I can take the application relatively briefly. There are two factual findings that I do invite Your Honour to make at this hearing. The first is that Mr. Mehta and Renish were in fact aware of the worldwide freezing order from on or shortly after the 2nd of August 2018. And I'll give you the evidence for that in due course, but I invite you to make that factual finding. And the second factual finding, albeit I recognise this is more difficult, is that assets belonging to Mr. Mehta and Renish have at least in part been used to fund their legal costs to date. And I appreciate that that is a more difficult submission for me to make, but I'll set out the evidence that I rely on in due course. So if I could turn to the first factual finding that I invite the court to make. Before I do so, I should just confirm, probably with Mr. Duckworth, that having heard everything and your lordship's refusal of the adjournment application, just to confirm that Mr. Mehta is electing not to give evidence orally. I should perhaps confirm that that's the position before I make my submissions.
Yes, Mr. Wheel is well aware, I've spoken to him on 2 occasions about this, that it is not intended to call my client. We don't feel in a position to do so. We don't have sufficient instructions.
Mr. Duckworth's quite right. He did confirm that to me over the weekend. I just wanted to reconfirm it for the avoidance of doubt at this hearing. So, Your Honour, let me deal then with the date on which the respondents had notice of the freezing order. There are some matters which I understand it to be common ground, or at least not disputed. The first is that Mr. Mehta personally knew that SBM was pressing for the repayment of the loan facility in June and July 2018. But despite those demands for payment, he left Dubai for India. And after that point, he ceased communications with SBM. Now, in my submission, the court should infer in those circumstances that Mr. Mehta knew that it was highly likely that legal proceedings would be issued and that those legal proceedings would be sent to him. Now, I'd like, if I may, to return to the grounds of appeal, which set out certain aspects of the respondent's case, and you can find that at N tab 8 and page 86.
Give me the reference again, Mr. Wade.
Sorry, it's N tab 8, and the grounds of appeal begin at N85, yeah. But I'd like to turn to N98, which corresponds to paragraph 15.
Right.
So I don't know if you have paragraph 15.2.
I do, yes.
So he says there that on the 8th or 9th of July, he flew to India to attend a wedding. But in fact, the true position is that he didn't return to Dubai thereafter. And so in my submission, one can infer that he essentially fled the jurisdiction, knowing that SBM was chasing for payment. Now, at paragraph 15.3, rather confusingly, there are 2 paragraph 15.3s. So if you skip over the first and go to the second, that begins considering the position of Renish. Do you see that?
Yes.
So what is said there at line 3 is that Mr. Mehta decided it was in the best interests of the employees to discontinue its business and terminate employment contracts. And at 15.4, there's a reference to the absence of staff at Renish's offices. So, put another way, Your Honour, Mr. Mehta's reaction to the demands for payment that were being made by SBM was to terminate employment contracts and abandon the offices of Renish. And in my submission, that is obviously dishonest conduct in all the circumstances. Now, if you look at the last paragraph on that page, it said that owing to the above reasons, Mr. Mehta from mid-July was unreachable for communication by SBM. But that is not the true position, because the above reasons do not explain why Mr. Mehta could not have telephoned SBM, or why he could not have continued to access his emails. And in my submission, it is to be inferred that he did so. What happened instead was that Mr. Mehta was simply ignoring correspondence and ignoring attempts to contact him. If you could turn please to 01, page 1, you'll see the first affidavit of Mr. Chung in support of the committal application.
Where you want to see?
Section O, tab 1. This is the committal hearing bundle.
Yes.
And you'll see
yeah,
the
the evidence.
I'm grateful. Could you scroll down to page 6 until you get to paragraph 33?
Right, yes.
And this is important because, well, if you look at paragraph 30, you can see that it was sent to various email addresses at Renish. And then the important one for present purposes is md at renishpetrochem.com. Because that is Mr. Mehta's personal address. And what's said at paragraph 33 is that Musthirga Murthy, who was the person at Denton's who served the freezing order by email, received bounce backs on some emails because they were too large, but not on other emails. And she did not receive a bounce back from the email that was sent to Mr. Renish personally. Now, Your Honour, if the email account had been closed as at that date, all emails would have bounced back. But tellingly, the one containing the freezing order did not. Now, having considered that evidence, could you please turn back to the grounds of appeal? So if you go to tab N8 again, and look at page N99.
Yes.
And I invite Your Honour's attention to 17.1.
Whose evidence is this?
It's not evidence, Your Honour. This is Mr. Mehta's grounds of appeal.
Oh, yes.
But it's setting out his case.
Yeah.
Now, the relevant bit is 4 lines from the bottom. And what is said here is, as no business activities were being carried out, the email servers also became inactive in some time. Now, There are 3 points that I wish to highlight. The first point is that Mr. Mehta does not in fact state the date on which the email servers became inactive, and therefore he does not identify that they were inactive on the 2nd of August when the freezing order was sent. The second point I identify is that no underlying evidence, including any correspondence or documents relating to the respondent's email server, has been produced. This is just a bare assertion, unsupported by any evidence. And the third point, which is the point that Your Honour just alluded to a moment ago, is that Mr. Mehta himself has not addressed this in his witness statement. And he is unwilling to give oral evidence to the court today, and therefore I can't explore with him when his email server became inactive. But in my submission, based on all of the matters that I've drawn to your Lordship's attention, there is ample evidence for this court to conclude that Mr. Mehta, and therefore Renish, in fact received the freezing order on the 2nd of August 2018, when they were emailed to them by Dentons. And if your Lordship reaches that conclusion, it follows that the breaches are extremely serious, because it will follow that Mr. Mehta and Renish have done nothing for 2.5 years in response to them. So that's the first factual finding I invite you to make. The second finding, which I appreciate is more difficult for me to make, at least in the context of a finding to the criminal standard, is what funds have been paid to Ashish Mehta since October of last year. Because you've seen, Your Honour, that they have prepared 2 very lengthy grounds of appeal, which must have taken a considerable amount of lawyer time to prepare, based on the background reading that they would have needed to do in order to produce those documents. Now, in my submission, in the absence of very clear evidence to the contrary, and I stress evidence as opposed to assertions in correspondence and skeleton arguments, in the absence of that evidence, it is inconceivable that a law firm like Ashish Mehta would have acted for no payment for someone who this court has found to have committed fraud and whose assets were subject to a freezing order. So in my submission, in the absence of compelling evidence, it is to be inferred that some funds have been paid to AMA, and that those funds derived from assets belonging to Mr. Mehta or Renish. And it is striking that Mr. Mehta, in his witness statement, has not told the court how he has funded his outgoings over the last 2.5 years, in circumstances where his assets ought to have been frozen. So it is to be inferred that in fact Mr. Mehta has ready access to his own assets, and that he has chosen to apply those assets in order to fund his current lawyers. And if Your Honour were to make that finding, that would constitute a further breach of the freezing order, because in addition to failing to provide disclosure about his assets, Mr. Mehta has in fact used his assets, and Renish has used its assets to pay for its legal fees.
Well, we do have the letter now that about a third party spending
The letter that you have, Your Honour, is to the effect that since January of this year, a third party funding arrangement has been put in place. But what you don't have evidence of is that AMA has not received a single dirham in respect of its fees since October. And in my submission, in the absence of evidence, that is a very unlikely proposition, because no self-respecting law firm would act for someone who's found to have committed fraud and has a freezing order imposed on them without having obtained at least some payment. So those are my submissions in relation to the two short factual findings I invite you to make. The easiest thing now is probably to look at the application and grounds, which you'll find at section O of the application bundle behind tab 5.
Right.
So section O, tab 5, you'll see the grounds for the committal application.
I have them, yes, before me.
I'm grateful. If you scroll down to paragraph 9,
Right.
You've already seen this, and you're on as well familiar with it, but the obligation was within 2 days to set out to the best of their ability all of their worldwide assets exceeding $10,000 and what happened to the monies paid to the NBK account. And then paragraph 10 required them to put that information in the form of an affidavit. Now, I just want to go through each breach individually, but I can do so very briefly. So starting with paragraph 14, Renish has failed to provide disclosure of its assets. In my submission, that is unarguable. We've been told about bank accounts, but no information has been provided. Breach 2, Renish has failed to provide any information as to what's become of the sums transferred to it from the applicant. Now, in that regard, could I just remind you of the circularity of the payments, and in particular, what's pleaded in relation to it? You'll see that at section G, tab 3.
Section G.
I'm sorry, I think, well, the easiest place to find it is actually tab N.
N, yes.
And if you start at page N18, you'll see the particulars of claim. And then if you scroll down to N33,
yes,
what you'll see there is a table which explains that in addition to round figure sums, if you go down to paragraph 58, some $7.8 million went back to Renish from the NBK account. So when my learned friend says that they don't have access to information about Prime's account or knowledge about that, they do know, or they ought to know, that substantial sums have come back to them from that account. And in any event, what the order requires them to do is to set out the matters to the best of their knowledge and belief. If their honest evidence was that they simply have no idea what happened to the sums that were paid into the NBK account, they should set that out in an affidavit and say, we don't know. But they haven't said anything at all, and so they've simply failed to comply with section 9.2 of the order. If I could return, if I may, to the grounds. So we were looking at section O, tab 5, and I think we've got to paragraph 15, which is on O228.
Yes.
So if we turn then to breach number 3, which is at paragraph 16, we say that Renish failed to swear and serve an affidavit setting out the information. Well, they clearly have. So that breach is obviously established. Breach 4 depends on you making the second factual finding that I've invited you to make. If you do make that finding, it will follow that breach 4 has been committed. Now, breach 5 is exactly the same breaches, but as against Mr. Mehta, and in my submission it is obvious that each of the first 3 breaches is established because Mr. Mehta has not provided information about his assets. And again, breach 8 will depend on what finding you make about expenses relating to AMA's fees. And lastly, breaches 9, 10, 11 and 12 are simply Mr. Mehta being responsible for Renish's breaches because he is the owner and controller of Renish. So if you find that Renish has committed those first 4 breaches, it automatically follows in my submission that Mr. Mehta is responsible for those in his capacity as owner and controller. So in a sense, that is my case. I want, if I may, to turn to what Mr. Duckworth says about the breaches in his skeleton argument. And you'll find that at paragraph 14. His skeleton argument itself is at tab 8 of section O. So I want to pick it up at 0254.
Yes.
So I'm going to deal briefly with each of the substantive objections that Mr. Duckworth has made to the committal application itself. So starting with paragraph 14, Mr. Duckworth makes the point that there's a requirement under the rules that each breach be set out numerically and separately. As I explained to Your Honour at the outset of the hearing, we did do that. It was simply a formatting issue with the e-filing system that resulted in the application being consolidated. So then if you turn over the page, Mr. Duckworth's substantive defence essentially starts at paragraph 16. And what is said there is that their accounts in the UAE had been frozen, and therefore they encountered initial difficulty in complying with paragraph 9. Well, in my submission, that is a hopeless argument. They did not require access to their accounts in order to tell the court what assets they had. So that is no defence at all. Paragraph 17 says that they are now taking active steps to compile a full list of the defendant's assets. But again, that is a hopeless argument because they have known about the freezing order in my submission for over 2 years, and on the respondent's own case, they've known about it since October. So the suggestion that only now are they taking active steps is, if anything, an implicit recognition that until now they have done nothing serious in order to comply with the order. Paragraph 18 makes the point that only Prime knows what's happened to the monies in NBK's account. Well, there are 2 short answers to that. The first point is that some of the monies have actually gone back to Renish, and so Renish ought to be able to tell us what's happened to those. But the second, more fundamental point is that the freezing order only requires them to tell us what's happened to the best of their knowledge and belief. They're not required to tell us the full position if they don't know it. And on any view, they haven't done that. And so the respondents are clearly in breach of paragraph 9.2 as well. And then paragraph 19.
I do recall the prime evidence is that Renish in control of the documentation of the whole of the transactions and things like that.
That may well be so, Your Honour, and for present purposes, let me concede, or let me accept in the defendant's favour that all relevant documents relating to the Prime account are held by Prime. That does not mean that they simply refuse to answer the question.
Yes.
They should say, we don't know what happened to the money, or we believe that we may have had some money back from the NBK account, and we can't at this time be sure of
You mean at least they should have speak of memory, at least? If it's not
sorry, at
record.
least they should speak of.
They should have speak of memory, if not record.
Yeah, exactly,
No,
exactly. It's to the best of their recollection, exactly. And then, very finally, at paragraph 19 of Mr. Duckworth's skeleton argument, he says that they have no wish to violate the terms of the freezing order, and if allowed sufficient time, will do their best to provide all information. Well, that is an implicit acknowledgement that to date they have not done their best. And Mr. Duckworth quite correctly acknowledges that that submission sounds hollow, coming from parties who Your Honour has found are guilty of fraud. So, for all those reasons, Your Honour, this isn't a difficult case. It's not. There's no grey area. It is a very simple case. Once you look at Mr. Mehta's witness statement of the 12th of December and ask yourself, does that comply with paragraph 9.1 and 9.2 of the freezing order? The answer is very, very simply no. And before then, has Mr. Mehta and Renish done anything at all to comply with the freezing order? Well, their own case is that they didn't, because the only document that even attempts to comply with the freezing order is Mr. Mehta's statement of the 12th of December. So this is, as I say, a simple case where the court can be in no doubt that they have committed serious contempts, and in my submission the only inference is that the contempts were deliberate. Your Honour has seen that very, very lengthy grounds of appeal were drafted in October and November. It is very telling that the respondents have channeled their energy and their legal resources into fighting the appeal, when instead they should have been addressing the breaches of the freezing order and purging their contempt. And that is as clear an indication as any that they are acting deliberately in their own interests, rather than ensuring that they comply with the court's orders. Now, so far as the sanctions concerned, Your Honour, all we seek is an order that refers the matter to the Attorney General of Dubai. This court does not have a criminal jurisdiction, and to that extent you are spared a difficult question of what the appropriate sentence should be. That is a matter that will be looked at fairly and carefully by the Attorney General of Dubai in due course. All you need to do and can do is simply refer the matter to him for his consideration. So unless I can assist you further, or Your Honour has any questions, that very simply is the basis on which we say clear contempts have been committed and Mr. Mehta ought to be referred to the Attorney General of Dubai.
No, not at all. Thank you very much, Mr. Will. Mr. Duckworth?
Your Honour, I don't feel in a position to respond without taking instructions on the points that Mr. Wheel has made. So I would be grateful if the court would allow me a little time to do so. I think
Yes.
perhaps another 20 minutes in the circumstances.
Well, as I said, as I was proposed to you that I might give you a chance to submit a
Yes.
So, I'm prepared to give you 2 days or 48 hours
Thank you.
to submit an answer to today's hearing, and then liberty to the SPM to submit something else for another.
Your Honour, we can respond in 24 hours. So if we get something from Mr. Duckworth in 2 days, we'll
Yes.
respond the day after that.
I think this is the sensible way.
Respectfully submit that Mr. Wheel has had his say, and now it's for the defendants to have their say, and they should be the last in time, given that this is a quasi-criminal case.
Yeah, you mean you will need to have another third go in written submission?
Mr. Wheel doesn't need any further opportunities to come back to our points. He's already said all.
I don't know what their case is yet because they haven't articulated it. Until I've heard or seen their case, I do need an opportunity. But I accept Mr. Duckworth's proposition that if he wants the final say, then he can have a further 24 hours after my submission, which would take us to 4 days from today.
What do you think about this, Mr. Duckworth?
Well, with respect, it seems overcomplicated. Mr. Wheel opened this case by saying it's extremely simple, and now he's seeking to complicate it by further.
Not at all. You have 48 hours, then they will have 24 hours. They might not need to come back at all anyway. Then you will have another 24 hours.
I'm in the court's hands. I think I've made my point.
Yeah, I will take this point then. I will give you 24 hours to submit a written submission.
So did you 24 or 48?
Excuse me, 48 hours for you. Another 24 hours for Mr. Wheel. Then a final 24 hours for you, if you wish to say anything further.
Thank you very much.
Case adjourned. Thank you.
Thank you, Your Honour.
Thank you, Mr.